Okay, in this particular video, I wanted to be able to talk a little bit about this concept of due process. Within the school system, you will be directly involved with this process, especially when it comes to suspensions and being involved in those types of meetings with directors and your supervisor. It also becomes an important element when you are making decisions and putting it in writing, and having parents understand appeal rights to whatever decision you're making, whether it's related to an out-of-district or transfer, school placement, whatever it might be, and then ensuring that they are aware of what the next steps would be if they were in disagreement and would want to appeal a decision. So in order to be able to talk about that, I invited Ed O'Mealy, who is currently one of the lawyers for the Carroll County Public Schools. And many of you may know him because you had him for school law at McDaniel. First of all, I want to thank you so much for taking the time.
My pleasure.
And for those who don't know you, tell us a little bit about yourself and how you got to where you are.
Well, again, my name is Ed O'Mealy, and I'm an attorney at Pessin Katz Law in Towson. My partner, Rochelle Eisenberg, and I have been representing the Board of Education of Carroll County for many years. I've been doing work for the school system since the summer of 1986. As a young associate in that firm. I also teach at McDaniel College and have been teaching school law at McDaniel College now for 21 years this year. And beyond that, I'm also a graduate of Westminster High School, class of 1976. So Carroll County is home. It's where I live, it's where I raise my kids, where my grandkids are being raised, and so it's very important to me that we do things the proper way. And I've enjoyed the people that I've worked with in Carroll County Public Schools now for 30-something years.
So you can tell just by what he just said, there's a lot of experience in this whole process and this concept of due process. So I have a couple questions I want to ask him, and then through that you have a better sense of it and kind of your role within due process, within a school system. So, simple question, can you, in simple terms, give a definition of what due process is?
Sure. Well, due process is a fundamentally fair procedure. That's what the core of due process is all about. And in public education, we find the right to due process arising under the 14th Amendment of the United States Constitution, which provides that no person can be deprived of life, liberty, or property without due process of law. And within those terms, life, liberty, and property, well, obviously we don't have death penalty for students, so we can put life aside. Liberty, think about a student or an employee's right to their good name and reputation. So we always make sure that we abide by FERPA and we don't violate a student's FERPA rights when we're disciplining a student. Okay, so liberty should not be an issue. Property, because in Maryland, students have a Maryland constitutional right to an education. The court has viewed that as rising to the level of a property interest. And if you're in my school law class, or if you've had my school law class, you'll remember we talked about a very important Supreme Court case called Goss v. Lopez. And that's the case where the Supreme Court said, hey, because students have a property interest in the right to an education created under state law, if we're going to take away that right to an education through the suspension or expulsion process, then you have to provide them with due process before they're suspended. Okay, well, again, we go back to what is a fundamentally fair procedure. And the Supreme Court says due process at the school level prior to being suspended or expelled doesn't really require much. It's not a trial-like procedure in the principal's office. It's basically three things: notice of the offense, an explanation of the evidence, and an opportunity to respond. So if you can imagine the principal saying, Johnny Smith, I understand that you cut your third period class and you were seen smoking a cigarette over by the stadium bleachers. What do you have to say for yourself? And the student, upon being given that opportunity to respond, i.e., what do you have to say for yourself, says, well, I don't know who you saw, but if you check with my guidance counselor, she'll verify that I was with her during the entire third period. And if the guidance counselor verifies that student's alibi, well, the opportunity to respond saved that student from being suspended from school. Now, obviously, in a lot of situations, when the student is given an opportunity to respond, they kind of stammer and say, well, you got me, and I'm sorry for what I did, or whatever. And then we move into, okay, what's the appropriate disciplinary sanction based upon the offense? So obviously, due process comes up in the suspension and expulsion process. But it comes up in other contexts as well. And so we always have to look at not only whether the student's entitled to due process, but we have to determine what process is due. And so it varies. So there's a difference, for example, between a short-term suspension of less than 10 days or an extended removal up to 45 days or possibly even beyond 45 days, in which case under 7305 of the education article, the student is going to be entitled to more due process, including an evidentiary hearing before the Board of Ed, than the student would be entitled to for a short suspension of less than 10 days. Throw in special ed or 504. Well, now we're looking at manifestation meetings, and we're looking at making sure that we're not only following Maryland law as it applies to suspensions, but also federal law as it applies to IDEA in Section 504. Then we also have other situations where a student loses privileges rather than losing the right to an education. And then we have lesser protections under Section 4205 of the education article than we would under 7305, which is our provision on suspensions and expulsions. And so it comes up in a number of different situations where students and their families have the right to some form of fair process, due process, that allows them to be heard on the situation.
And then, so when you're talking about a student having due process, parent also has the same right. What advice would you give to a PPW who is making a decision, especially if they know that it's going to be one that's going to be, they're not going to like what you're going to say to them, whether, and things come up to me. One example might be, you deny an out-of-district where you won't allow a student to transfer to a different school. Mm-hmm. Or you say to a family, I have evidence that you no longer live in the county, so we're going to transfer the kid out after a certain date because through my investigation and through my contact with my supervisor, this is the decision that the school system's going to make.
Sure.
What advice would you give to PPWs when they're making those decisions?
Well, that's a great question. And even though a student and or parent or guardian would not have as great a right to due process as with a suspension or an expulsion, the examples that you gave are some of the most contentious issues that we deal with. Everyone wants to go to the school that they want to go to. And while we've somewhat relaxed the rules on attending out of district within Carroll County, if you're a Carroll County resident, I can remember not all that long ago when we were busting at the seams, back when we were a 29,000 student district, and every school was pretty much full or over capacity, and we were very tight on out-of-district placements, and we were saying no repeatedly. We had lots of appeals. And I think the important thing is that parents and students need to know why. What's the reason behind our decision? And we should try to get across them. This is not about some arbitrary whim This isn't because we don't like your kid or anything like that. This is based upon the needs of the school system. Now, with respect to families who live outside of Carroll County, we've had examples of that over the years where we've gone to court and we've contested guardianship. The judges in Carroll County, when they get guardianship petitions, maybe a grandparent or an aunt or uncle is petitioning for guardianship, the court looks at that and says, well, is this based upon some serious family need? Or are you just trying to do this so that your kid can get a better education in Carroll County than perhaps they could get in Baltimore City? And they're very skeptical of those, and they will call me up and ask if we want to intervene in those cases, and sometimes we have. There have been other situations where we've caught people using fictitious addresses or being dropped off at the bus stop, and after they have been removed from Carroll County Public Schools, we send them a tuition bill. So I think people need to know that. People need an explanation. Why is this so? I think that's first and foremost. But they do have the right to an appeal. Again, they don't get the same due process as they would for a long-term student suspension, but they do have the right to an appeal, and they could appeal to the superintendent. And they can appeal the superintendent's decision to the local board. And they can appeal the local board's decision to the Maryland State Board. But going back to that question of what processes do, remember I said you get more due process for a suspension beyond 10 days. The suspension beyond 10 days, you're entitled to a full evidentiary hearing before the local Board of Education, where the student has the right to present evidence and call witnesses and cross-examine the superintendent's witnesses. The student will have the burden of proof. They will have to demonstrate that the superintendent's decision or the decision of the superintendent's designee was arbitrary, unreasonable, or illegal. And the local board will be very careful to make sure that they meet that burden, because otherwise they're going to uphold the decision of the superintendent. The State Board will not give an evidentiary hearing on student appeals. On a transfer or a reassignment case, it's a 4205 appeal, and I don't mean to throw numbers out there, but think of this: 7305, student suspension and expulsion, more due process, and for anything over 10 days, full evidentiary hearing. 4205, it's probably going to be a paper review, meaning the parties have the right to an appeal, but they're going to submit everything in writing, and the board's going to review the writing, and they're going to make a decision based upon the written submissions of the parties. And so the local board, again, is going to place the burden of proof on the family, demonstrate that the superintendent's decision was arbitrary, unreasonable, or illegal. You have the right to a paper appeal to the State Board, and the State Board, again, will require that the parties submit written documentation to the State Board, and the State Board will hold the family to the burden of proof of demonstrating that the local board's decision was arbitrary, unreasonable, or illegal, which is a tough burden. Unless you can show that you were really living in the county, and there are examples of those, not from Carroll County, but Howard County is notorious somewhat for being very, very strict on out-of-district placements. And it's a popular place, and it's more crowded than Carroll. A good school system, of course, just like Carroll is a good school system. And they routinely reject students who they believe live outside of the confines of Howard County. And the State Board has looked at that and said, well, you know, the evidence seems to suggest that perhaps they really did live in Howard County. And so it's not a rubber stamp at the State Board, I'm not suggesting that, but the burden is on the family. And that's an important thing. They have to demonstrate that the decision of the school officials and the local board was arbitrary, unreasonable, or illegal. And arbitrary means that no reasoning mind could reasonably agree with the local board's decision. That's a tough burden of proof.
Say that one more time.
No reasoning mind could reasonably agree with the local board's decision. All right, so when you go out and you have a family visit, you show up and they're not there, and there's no evidence that they actually reside at the address that they've given, and you document that over some time, that's pretty strong evidence. But then again, there are cases where maybe the PPW shows up, they're not home, and they say, well, we don't think they live there, and they come back with, well, here are all of our BG&E bills, here's our phone bill, here's all the documentation, here's the affidavit from the landlord. All of that would have to be taken into consideration.
I think that's important for the PPW. It can't be arbitrary, it can't be illegal, it can't be, what was it?
Unreasonable.
Unreasonable.
Right.
And maybe you can talk about the other two in just a second.
Sure.
But it's important that when you are doing like investigation of a family is saying that they live in one address, and you would say, well, I don't necessarily believe you, and through your investigation, it's important that you document everything that you've done clearly within the school system's computer system for that kid and his notes,
Yep.
or through your own notes, which could be brought to court if it got to that kind of legal action. But when you are writing the letter and when you're consulting, you got to be wise about who you consult with, because if your decision gets appealed, it will not be appealed to the person you consult with.
Right.
Am I saying that correctly?
That's correct.
And when you write the letter, putting in writing what your final decision is, most of the time you will put at the end of your letter, that you have a right to appeal, and most of the time you can put in writing to the superintendent or his designee within 10 days if you think my decision is arbitrary, illegal, or unreasonable. Maybe you could just talk about that.
Yeah, and I think you just raised a very important point. We've been very good in Carroll County in notifying families of the process, advising them, if you don't like our decision for any reason, you have the right to submit an appeal to the superintendent within so many days, or if you don't like the superintendent's decision, you can appeal that decision to the local board within so many days. You don't like the local board's decision, you can appeal to the state board. I think it's fundamentally fair to advise families of the process, and it's also helpful to us when we're defending the appeal to demonstrate that we advise them of the timeline, who to submit the appeal to, where to submit it, when to submit it, because inevitably we're going to have a couple cases where they miss the deadline, and then we're going to file a motion to dismiss the appeal because it's untimely. And if we can show, look, we sent them this letter, and here's the process that we outlined in the letter, and there's really no reason why they couldn't have followed that process. So, we're not out to get anybody. We're trying to enforce rules and policies and procedures that were developed by the superintendent or by the board for legitimate educational reasons. And we're trying to hold our families to those policies and procedures. And when we submit the facts that support a decision, we want to outline all the steps that we've taken. We want to have our ducks in a row, dot our I's, cross our T's, demonstrate that we took the matter very seriously. It was never done in a knee-jerk fashion. It wasn't a rubber stamp. We weren't out to get anybody, but we can document everything that we did, why we did it, when we did it, and that makes it so much easier for us if we have all of our steps outlined and the supporting materials there when we submit that to the State Board of Education. along those lines, it's always important to have our policies and procedures outlined in advance. And so we have renditions of board policies on suspension, expulsion, board policies on change of placement, out of district placement and whatnot, contained in several different things. We can't expect most people to read board policy JFK, whatever that might be, but they can be expected to read the information that's in the school handbook, that's in the informational calendar, or what's on the website. And we want to be able to point to that, and those will usually be exhibits in whatever we submit to the local board and the state board, showing that people were informed in advance. And then when they made inquiry, we sent them another copy. And then when they came in for a meeting, we provided them with another copy. We again explained everything to them. And that's all part of the process. So I mentioned arbitrary, unreasonable, or illegal. Let's focus on unreasonable. Okay? We already said arbitrary is where no reasoning mind could reasonably agree with the decision, which is a very steep burden. Unreasonable is when it's contrary to sound educational policy. And sound educational policy dictates that we let people know the rules up front. We let them know the procedures that we're going to govern the school system by and hold parents and students by. And so we have those outlined in our various writings that we make available to students and their families. Then when it comes to decisions, something that might be contrary to sound educational policy is, when we catch somebody doing something wrong, are we going to remove them from the school system on the day before final exams? I think probably not. I think we're probably going to say, look, we'll let you take your finals, we'll let you finish out the marking period, depending upon when in the semester that discovery is made. Difference if it's in the beginning of the marking period or towards the end of the marking period. But I think that sound educational policy very often is a common sense thing, and we want to be able to show the people who look at the school system, whether it's the State Board of Education or whether it's the circuit court or even the federal court, depending upon how litigious the family might be, that we dictate the school system from the point of view of being there for kids, first and foremost, and that we use common sense. And so I think that that's part of being reasonable, sound educational policy. We can justify why we have these rules in place. We can justify the decision that we made. We can justify the sanction that we imposed, and when we imposed it, and why, and how.
I think the balancing act for PPW is because you're trying to build relationships with families and do what's in the best interest of students. But you also have a fine balance of there's a formal part of me that has to adhere to certain guidelines, and I cannot waver from that. Mm-hmm. And then the other part that says I'm still trying to build a relationship with a family, and I want to do what's in the best interest of this student. And so, in those conversations, you're doing what you can to say the formal part of me has to say this to you, but here is some, this is something we could do, but I would have to maybe see my supervisor, or if there's any flexibility to the guidelines or to whatever policy that would be applying in that particular case, because you're trying to be reasonable but also be fair to what the system requires versus what the parent would want.
Yeah, and speaking to that, I think that the philosophy in Carroll County is definitely student-centered. We have so much fewer suspension, expulsion appeals than we did at earlier times. And I think, if I might be so bold as to suggest, I think our discipline philosophy is a little bit different than it perhaps was at one point. You know, it's less punitive, more rehabilitative, I think.
Mhm.
I think that's fair.
I think it's fair.
And so, you know, when a kid does something wrong, and there's going to be a consequence for that, we're not just looking to punish the kid. We're looking at what can we do to help this student continue his or her education, be successful, learn from the mistake, turn this around, and go forward. And one of the great things about Carroll County is we have a wide variety of alternative educational opportunities. That's very impressive. Not every school system in Maryland has the menu of alternative education opportunities that Carroll County has. You know, I've been in many a suspension conference over the years. I've probably been in over 100. And, you know, parents can be pretty upset. They're angry at their kid, they're angry at the school, they're angry at the school system, they're just angry. And I think the role of the PPW in those suspension conferences is part to kind of turn that around a little bit and say, okay, well, where do we go from here? And how can we help your child to be successful? And sometimes parents, when looking at the alternative educational opportunities, will have a preconceived notion. Oh, I'm not going to go to Gateway. My kid's not going to go to Gateway. That's where the bad kids go. Well, that's not necessarily where the bad kids go. That's where kids who need the structure are able to go and be successful when they weren't meeting with success at a regular comprehensive high school or middle school. And I've seen so many kids over the years who have benefited greatly from alternative education. And I'll tell you, I've got a child who finished up at Flex, you know, for medical reasons, but you know, and you know, the opportunity to have alternative education in Carroll County is tremendous. Not every county has what we have. And we were smart to invest in alternative education when we did. Very, very smart. So the PPW in the suspension conference is there to say, look, here's what we can do. You know, your child doesn't have to be home. That's the last thing we want. We don't want the student who's suspended to be sitting home without anything to do. We want that student to be able to move forward with his or her education, and the PPW helps turn that difficult student suspension conference around into something positive. Where do we go from here? How do we help your child to be successful? Very important.
And I do think, and that was one of the questions, how you see it playing out in student services, and we've already talked about all those scenarios. But you will find that in your role as PPW, you will sometimes be the only person that they will listen to because they are so irate and so upset, and that you are the only person to listen to where they would calm down enough to be able to listen and kind of understand the process of due process and of what the options are to go in a different direction or to try to move this forward, just versus just being stuck in litigation or stuck in just having the kid be home or whatever it might be. But so you know, you see all the little pieces that make due process a big part of what a school system does, how they carry it along their business, and how they make decisions, and how they inform people of their guidelines. And that's why we inform what our policies and practices will be, and websites and letters and brochures and calendars and such. So these are just talking points that you have to keep in mind as you take on the role of PPW. Anything else added regarding due process?
Well, you know, it makes sense. Think of it this way. I'd rather provide more due process early on than I have to. rather than spend a couple of days in court. And I think you all would rather do that too. So let's make sure that we provide that fundamentally fair procedure. Let's make sure that we follow the rules to a T. And that way we can justify our decisions at the lower levels, either before the superintendent or the local board, maybe before the state board, rather than in the circuit court for Carroll County or in the U.S. District Court. We're going to be there sometimes. You know, it's inevitable. Every once in a while we get cases where we find ourselves in court. Some parents just will not stop litigating. Well, we're ready for them. You know, they may have lawyers, but we've got lawyers too. And we're very happy to defend the school system, especially if we can show that we followed the steps, that we provided the due process, that we provided the documentation, that we advised of the rules up front. You know, it's not only appropriate for the families and the students, but it saves us a lot of time in the long run. And it's well worth the investment of time and effort in making sure that we do it right the first time.
So things to consider, and we will have a discussion board question related to this. And that's it.